Dear students, I, Sunita Tripathi, am an assistant professor at the Jindal Global Law School, where I teach courses related to intellectual property law. Today we shall discuss the module on the concept of distinctiveness and the grounds for refusal of trademark registration. The aim is to familiarize you with the fundamental concepts of distinctiveness as a notion required for trademark protection and the relevant absolute and relative grounds for refusal of such registration, the legal provisions as well as case law. At the end of the module, you are expected to have grasped the fundamental concepts of what is known as acquired distinctiveness and inherent distinctiveness, the contradictions and tensions between confusingly similar trademarks for goods and services, as well as be able to conduct case law analysis to identify the relevant legal principles supporting decisions pertaining to the grounds for refusal of such trademark registration. Let's begin with some fundamentals first. Trademark as such needs to have a notional function. The function essentially is to mark the source of the good. So if we are to explain the functions of a trademark, they are firstly to indicate the origin of the product. That is, one good can have only one origin, that's the presumption. The second, the quality of the product, which is related to the goodwill of the business. And finally, to differentiate the product. And this is the distinguishing factor which is also going to be discussed at length under the notion of distinctiveness. The idea is that the trademark would then distinguish market goods and services from those of its competitors. As such, registration for trademark is not necessary because the life of a trademark essentially depends on its actual use. The section 47 of the Trademarks Act 99 itself provides that the trademark may be removed from the register in case of non-use. However, what is important here is the term and the length of protection afforded to trademark once it is registered. The initial registration of a trademark is for a period of 10 years, which may then be renewed from time to time upon payment of renewal fees, which can go on to perpetuity. So in a sense, a trademark protection can last from 0 to infinite number of years, and that is why traders look to register trademark. Section 6 of the Trademarks Act provides for the registry, and after the amendment of the 99 Amendment Act of the Trademarks, there is a single register with a simple procedure with no two Part A, Part B legal rights and distinctiveness required registered, but essentially it is just one single register to facilitate easy trademark registration, that being the latest. Let's go back to understanding what is this notion of distinctiveness and why is it so important a registrability criteria for a mark. Essentially, distinctiveness is required to exclude marks which do not even perform the basic function of distinguishing between two goods and products. The courts have held in the matter of Imperial Tobacco versus Registrar in the year 1977, and this is a Calcutta High Court judgment still reiterated several times, to define distinctiveness as some quality in the trademark which earmarks the goods so marked as distinct from the other products or such goods. So the idea is distinctiveness may either be inherent or even acquired. And the notion of distinctiveness is essentially to segregate between two competitors' goods and services. So an ideal trademark according to Indian Trademark Act would be one which is distinctive, which is non-descriptive and not generic. For example, Yahoo for a search engine. Yahoo as such is an invented word, has no specific dictionary meaning, and when attached to a product and service such as search engine, goes on to emanate a new function of distinguishing that search engine from its proprietor. Acquired distinctiveness is also known as secondary meaning in the United States. It may be assessed based on several factors which include customers' perception of displaced primary meaning in the mind of the consumer, the exclusivity of the use, the manner of the use, the duration of such use, and the volume of goods marketed, advertisements, and consumer surveys. Essentially, marketing strategies go on to decide a consumer's preference, and that goes on to be called as acquired distinctiveness. What would be inherent distinctiveness? Before we go on to understand that, let's familiarize ourselves with a few terms and words associated with the kinds of marks. And I'm going to rely on Justice Learned Hand's judgment in the case of Abercrombie and Fitch versus Hunting World, where Justice Hand essentially goes on to describe a spectrum of distinctiveness to assess the strength of a mark. And this spectrum goes on from the strongest mark being a fanciful mark. A fanciful mark is one which is absolutely imaginative, creative, never known to the world before. The best example for such would be an invented word such as Kodak for camera. Kodak as such has no meaning, but when attached to the service of camera, goes on to inherently become distinctive and new, and therefore is easily identifiable by the consumer looking to buy and purchase a camera from Kodak. The next strength of a mark would be assessed on the basis of what is known as arbitrary marks. Arbitrary in a sense would mean something which is not reasonable, and therefore you go on to attach a meaning of a separate word and juxtapose it to the goods and services which is different from the characteristic of that word to go on to build a new meaning. The best example of that is Apple computers. Apples are fruits, and no computer is essentially a fruit marketing. However, when you attach a word such as Apple to computer, it goes on to evolve a new meaning and attaches itself to the consumer who's looking to buy a computer which is labeled as Apple, because it originates from a particular company and has a certain quality standard as and when the consumer requires to be buying it. The next standard would be what is known as suggestive mark. A mark would be known as suggestive when a certain degree of imagination leads the consumer to associate and identify that mark to the good. For example, to reach a conclusion as to the nature of the good essentially would be without describing the quality of the good. The best example that comes to mind is Jaguar for the fast car. Jaguar is a fast animal. However, when you attach a word such as Jaguar, an animal, to a fast car, it essentially means that these cars are fast moving vehicles, and that is what a consumer goes on to understand from such labeling. Next would be a descriptive mark. Now, descriptive marks in a sense are known to be weaker marks because they go on to describe the character or the quality of the mark in itself, and thereby not being helpful in distinguishing goods and products, because in a sense most of the goods in the same class would have the same distinguishing feature. And so a descriptive mark is really not a strong mark but a weak mark. The best example of that would be an example of lens cart for optical lens markets, or even computer land for a place which is known as a computer store, which essentially means it's a land of computers or it's a cart of lens. Nothing much to be described more. The aim is essentially to protect the public by keeping descriptive signs and indications for use of all traders, and so that nobody essentially goes on to have a monopoly-like right over these public domain words for the simple fact that they can be descriptive and be useful to other traders in the trade as well. And finally, what is known as generic marks. Generic, as it suggests, refers to the genus of a particular product as a species. Essentially, these words are customary to trade, and therefore they are taken away from the domain of protectability as trademarks. And the examples of such would be words such as, say you are selling a product, milk product, and your product is termed as milk. In a sense, every other person who is in the business of milk parlor will not be able to use the word milk for the product, and therefore you are not allowed to be labeling or using a mark such as milk for your product, which is milk. The other phenomena which is upcoming is what is known as genericide, and that's an unfortunate incident when an absolutely fanciful and invented word goes on to remain in the public memory for so long that it becomes attached to the good itself. The example for such case would be Xerox. Xerox was an invented word attached for the service of photocopying. However, today in time and age, people use Xerox as a substituted word for photocopying, and thereby there is confusion if Xerox is a company in itself or the function or the art of photocopying. So it might come back to be becoming confusing in differentiating between two kinds of photocopying machines. So let's go back and understand the words we just learned. So Justice Learned Hand, in the matter of Abercrombie Fitch and Hunting World, laid down these principles of distinctiveness through a spectrum where the fanciful mark was the strongest, the arbitrary coming next, the suggestive, descriptive, and finally generic being not protectable. So we moved from a spectrum of absolutely protectable, easy and strong marks to the weakest and not protectable marks. Coming back to the Indian scenario, Section 9 of the Trademarks Act 99 lists out certain absolute grounds for refusal of registration of trademarks. Essentially, it relates to the intrinsic qualities of the mark. When you say intrinsic qualities, you're looking at the functions that the mark is supposed to satisfy. That is, indicate the origin, the quality, and distinguish the good from other competitors. So this act provides the mark should not be devoid of distinctiveness in the first place. Second, it may serve in the trade to designate the characteristics, the quality or of the goods and services. And in that sense, the intended purpose of the good becomes descriptive. The geographical origin or the time of production of the goods and rendering of such services will be described. And finally, the marks which consist exclusively of marks or indications which have become customary in the current language. So customary words of the trade cannot be used. These are very similar, going back to what are the strong marks, to what are descriptive marks, and to what are generic marks. And like I mentioned before, Indian Trademark Act requires trademarks to be distinctive, non-generic and non-descriptive. Furthermore, absolute grounds for refusal would be when an act also provides marks which will probably not be registrable if they cause confusion in the mind of the public. You must understand a trademark is looked at from the perception of the consumer. The consumer looks to buy a product based on his or her preference, and this preference is essentially an indicator of the goodwill of the trader in the market. So if two goods look similar or appeal to the consumer in a similar fashion, causing confusion in the mind of the consumer, that leads to lack of sales or poorer marketability, and therefore causing this confusion would sometimes be read as deceiving the public. Secondly, if the mark hurts religious sentiments of any class or sections of citizens of India, it will not be a ground for registrability. Further, any scandalous or obscene matter is not protected as a registered trademark. And finally, marks which are statutorily protected under the Emblems and the Names Prevention of Improper Use Act of 1950 ought not to be used as a trademarks at all. Shape as a trademark is a typical example within the Indian law, where Section 9 Clause 3C categorically mentions that the shapes of good which result from the nature of the good themselves, or a shape of good which is necessary to obtain a technical result, or perhaps a shape which gives substantial value to the good, cannot be a registered trademark. However, let's visit the trademark rules for a bit and understand that the Indian Trademark Registry's draft manual of trademark practice and procedure provides a contextual framework clarifying the position of whether a shape is really a protectable trademark within the Indian Trademark Act. So when Section 2(1)M, which describes what a mark is, and it's read with the draft TM manual, it clarifies that certain categories of marks such as shapes, color, sound and smell will require special consideration. What it essentially then means that there is room for judicial reasoning so as to understand whether there is registrability of shape as such in trademark. So far, shape has not been granted as a registrable trademark. However, in the States, a good example would be the Coke bottle. The shape of the Coke bottle is known as a trademark for Coca-Cola. Section 9 of Trademarks Act 99 describes what is non-descriptive words. Non-descriptive words essentially would mean words which are already there in the public domain and cannot be used to have any direct reference to the character or quality of the goods. So in a sense, if there is any word other than an invented word which has to be distinctive in order to be registrable, and finally there cannot be any direct reference to the quality or character of the goods, and finally it must not be laudatory. So in that case, a good example would be to visit and understand what does the court mean by non-descriptive words. In the case of HD Corporation versus Deputy Registrar of Trademarks in 1955, the Calcutta High Court has described that the word rasoi, which in Hindi means essentially a kitchenette, is known to be a descriptive mark when it comes to a cooking oil product. In a sense, the consumer is aware that this product is meant for cooking within the kitchen, and therefore the court held it to be a mark which describes the character and has a direct reference to the character quality of the good which is known to be sold, and was held to be non-registrable. Another example is a geographical name. Geographical indications are essentially a geographical area which are indicating a source of a product of certain value. Section 9(1)D explains a geographical name is prohibited from being registered as a trademark. The object of the legislature in not protecting geographical names is to prevent a trader from acquiring a monopoly in the name of a place. That means it might go on to mislead another consumer that the source of the good is essentially that place, because geographical indication is now protected under a separate statute altogether. However, the geographical name can still be granted registration upon evidence of acquired distinctiveness. Acquired distinctiveness, as I mentioned earlier, depends when the trademark is already in the market, is being used, and thereafter the consumer is identifying that trademark through its marketability as having a certain distinctiveness or having a certain quality or a reputation for its own. Example for a geographical name would be Shimla. Shimla is a place, a hill station in India essentially, but the mark Shimla was supposed to be applied for registration for a good such as tobacco, and it was denied any registration for the simple fact that the court held in Imperial Tobacco vs. Registrar again in 1968 that Shimla cannot be protected as a trademark. Other examples or other provisions within section 9 would be surnames, personal names, etc. Surnames as such or family names as such are not allowed to be protected as trademarks, and they are absolute grounds for refusal of such protection. Prima facie they are not registrable, however. However, family business can eventually go on to acquire distinctiveness in the minds of the consumer and earn goodwill and thereafter be registrable. A good example to think of would be probably the famous names of Tata, Ambani. Cadbury also is a good example of a surname essentially enjoying registrability for confectionery products upon evidence of distinctiveness. Further, letters, numerals, such as numerals would be, say, 555 for a detergent powder, or slogans and portraits of traders. For example, MDH Masala has the founding member as the mascot of the product, etc., representing goodwill, may not be registered prima facie, but may be registered upon proof of distinctiveness. And finally, portraits of national leaders such as Mahatma Gandhi or even historical monuments such as Taj Mahal cannot be registered as trademarks under the law. Next, we discuss the relative grounds for refusal of registrability of trademark. Section 11 of the Trademarks Act 99 discusses this. Essentially, it relates to conflicts with earlier trademark rights belonging to third parties. A mark shall not be registered if there is likelihood of confusion and likelihood of association by virtue of its identity with an earlier trademark or similarity of goods and services caused by such earlier trademark. For example, the Olay body lotion and an OK hair shampoo. Essentially, they both come back to becoming beauty products used by ladies, and if they are deceptively similar to each other, they can go on to confuse the consumer of imperfect recollection or ability to judge the difference between the two goods because of them being identical or similar in many ways. Also, because the class of goods are same and the font, the presentation, the packaging is deceptively similar. So there is a high likelihood of confusion or likelihood of association in that case. Before rejecting on these grounds, it's important to understand what is this earlier trademark. An earlier trademark is any trademark which is already in the market and is being used by the proprietor, whether or not they are registered or whether it is a common law trademark, and therefore an action in case of a second mover would be an infringement in case of a registered trademark or passing off in case of a common law trademark. Does the opponent have the appropriate interest on which to base a challenge is important. And finally, has the earlier mark been used? Like I mentioned earlier, the strength or protection of a trademark is only as long as it is in use in the market. Next, let's understand likelihood of consumer confusion being the hallmark of trademark infringement. The best examples to understand is drinking water. For example, if packaged water such as Bisleri, which is wrapped with a blue label and a flapel in that sense, and another bottle with a Billuri, which is again packaged water, there can be huge confusion because of their deceptive similarity. A consumer looking to drink water may end up drinking another water thinking it to be coming from the first one. And the analogy or best commonplace example would be, say for example, your mother asks you to run an errand and buy the white detergent she uses to wash clothes. You go to the shop, you see a plethora of options which are white detergent, and you do not know which exactly is your mother's preference. So you pick up one packet under the assumption that probably your guess is right. Or you ask the seller, who then sells you to the best of his knowledge what would be your mother's preference, which is questionable then, because your consumer, that is your mother, may then feel to have failed the idea of having a preference in the product, because the quality or the nature of the product cannot be judged by simple white packaging. So what Trademark essentially then did was labeled it to help identify the product and the preference of your mom. The second option would be, if again you're supposed to go on to pick up, say, detergent X as opposed to detergent Y, which is white packaged, and by the time you actually come to the shop, you forgot whether it is X or Y, how difficult is it to change a Y to an X? And so you're confused at the store and you buy whatever is, to your mind, most suitable for your mother. This again might be questionable about the quality and the standard of the product that your mother would be preferring. So all of that essentially leads us to understand what really confused you. A, you are a consumer who has imperfect recollection, yes, but it is you that the market wants to serve. And essentially other examples would be, say for example, the Nike swoosh. Nike has merchandise in clothing as well, and a similar recent market sales essentially mention a second mover writing "I like" with the same sort of swoosh, then confusing the consumer whether it originates from Nike itself or not, and therefore an action for infringement, or even for that matter dilution, can be applied. Other example, or a good case law to discuss at this point, would be Hoffman versus Jeffrey Manners. In this case, the subject matter is essentially vitamin preparations. So Protowit was registered for one of the vitamin preparations manufactured by the appellant company in this matter, and the respondent company applied for registration of its mark Dropowit in respect of medical and pharmaceutical preparations and substances, and the application was granted. Later on, the appellant came to know about this trademark and it asked the respondent to alter it. On refusal from the respondent, the appellant went on to ask for rectification of the register and removal of the respondent's mark from the register. The question that fell for consideration before the court was whether the word Dropowit was deceptively similar to the word Protowit and thus offended the provision of section 12(1) of the Trademarks Act. And finally, secondly, whether the word Dropowit was an invented or a descriptive word for the purpose of section 9(1). The court went on to understand that Dropowit essentially would mean to have been broken out to be meaning as a vitamin supplement. However, it does not directly end up describing the product, and the court held that in order for a trademark to be found deceptively similar to another, it is not necessary that it should be intended to deceive or intended to cause confusion. It is its probable effect on the ordinary kind of customer that one has to consider. And so the word Dropowit, being an invented word as such, was entitled to be registered as a trademark, and the appeal was held in favor of the respondents. The other way of understanding relative grounds is the trademark shall not be registered if its use in India is liable to be prevented by the virtue of any law. By any law, furthermore, it actually mentions the law of passing off, that is protecting an unregistered trademark in the course of trade, and by virtue of the law of copyright. To be noted here, though, is the consent of the proprietor of the earlier trademark to the second mover can then validate the registration of the second mover. Essentially, clause 4 of section 11 says, nothing in this section shall prevent the registration of a trademark where the proprietor of the earlier trademark or other earlier right consents to the registration, and in such case, the registrar may register the mark under special circumstances under section 12. So when can a trademark not be refused registration? It is to be noted when the consent of the proprietor of the earlier trademark is given, and unless objection to any one or more of those grounds is raised in the opposition proceedings by the proprietor of an earlier trademark, the trademark may not be refused registration. Furthermore, a well-known trademark is required to be protected under the law, because a well-known trademark as such is a mark which has acquired its distinctiveness in the minds of the public and is already as a first mover in the market. So while considering an application for registration of a trademark, an opposition filed in respect of such a well-known trademark, the registrar then shall protect a well-known trademark against identical or similar trademarks. That means the second mover to the well-known trademark will not be allowed because of relative grounds of similarity. The next is how to assess this relative ground of deceptive similarity. It would actually go on to be a comparative analysis done by the court to assess the extent of similarity in that sense. Where a trademark has been registered in good faith, disclosing the material information to the registrar of where right to a trademark has been acquired through use in good faith before the commencement of this Act of 99, then nothing in this Act shall prejudice the validity of the mark or the registration of such a mark or the right to use that trademark on the ground that such trademark is identical with or similar to a well-known trademark. So in a sense, we have covered a plethora of issues here. We started by understanding the term of the trademark, the importance of registrability, then the grounds for refusal, as well as the absolute and related grounds that the court applies to accord a grant of registration for a trademark. Let us go on to summarize what we've learned so far. Section 9 of Trademarks Act has listed absolute grounds for refusal of trademarks. So we began by understanding what essentially means to be the intrinsic quality of a mark, and these intrinsic qualities directly relate us to distinctiveness. So mark should not be registered if it is not of a distinctive character. And we went on to understand, by virtue of an American case law, the spectrum of distinctiveness on a level of marks which are described as being fanciful, which is an invented word not available to the public before such word was invented. Example that was discussed was Kodak. Next was arbitrary, where a separate word was attached to a new good or service to attach and bring out a new meaning. The example we discussed was Apple computers.